There's a specific kind of quiet that belongs to 3 a.m. in late November. No birds, no wind worth mentioning. Just frozen ground under boot leather and the sound of a gate chain being fed through rusted pipe. I want to be clear about something before I tell you what happened that night. I'm not a man who operates by darkness. I'm not a man who makes moves he can't explain in full daylight, in plain language, to anyone who asks. I'm 61 years old. I've owned the same 42 acres in the Blue Ridge foothills for 19 years. I pay my property taxes on the 1st of every month, not the 15th. I keep records the way my father kept records, in a fireproof box, organized by year in triplicate, every document dated and signed by at least one witness. The county sheriff's deputy who arrived at the gate that morning, the Hargrove Mountain Resort had called him, not me, looked at the folder I handed him for a long time without speaking. The gate was open behind me. 80 feet up the ridge, 2 timber trucks were already running their second pass of the morning. I could hear the diesel engines through the tree line, steady and methodical, the way a working machine is supposed to sound. The deputy turned over the first document, then the second. He looked at the recording stamp in the lower right corner of the third page. "This is a county record," he said. It wasn't a question. "Filed in 1974, I told him. "Predates the resort by 47 years, predates the Caldwell family's ownership of that land by 6. He folded it carefully, handed it back, and looked over his shoulder at Derek Voss, the resort's property manager, who was standing 20 feet away in a fleece vest with the Hargrove logo embroidered on the chest, his phone pressed to his ear, his breath fogging in the cold. "Sir," the deputy said, walking toward Voss, "I'm going to need you to step back from the easement corridor." I put the documents back in the folder. Behind me, the trucks kept running. I never fought the Hargrove Mountain Resort. I want you to understand that before anything else. They filed the complaints, they sent the letters, they poured the concrete and installed the gates and hired the attorneys and made every move they made. I just made sure the paperwork was in order when they did. There is a difference between fighting someone and simply being ready for them. I had spent 19 years on that land learning the difference. I bought the 42 acres in March of 2003, at the tail end of a wet winter that had turned the lower pasture to standing water and made the gravel access road nearly impassable in a standard pickup. The realtor who showed me the property drove a 2-wheel drive sedan and got it stuck twice in the lower run, both times in the same muddy depression where the road dipped near the creek crossing. I didn't hold it against him. I pulled him out with a tow strap I kept behind the rear seat, and we walked the remaining quarter-mile on foot. And by the time we reached the eastern tree line and I could see the upper 40 spreading out above us in the late winter light, bare hardwood, the skeletal pattern of oak and tulip poplar against a pale sky, I had already decided I was buying it. It was timber country primarily, second-growth hardwood on the upper 40 acres, a mix of oak and tulip poplar and enough black walnut scattered through the understory to make the land worth managing carefully over time. The lower 2 acres were open pasture with a seasonal creek along the south boundary, and those I intended to keep as meadow and buffer. Before I bought the property, I had spent 12 years working as a licensed land surveyor for a firm based out of Asheville. I knew how to read a property. I knew how to read a deed. I knew what the numbers on a survey plat told you about what you actually owned versus what you merely occupied and where those things diverged. When my closing attorney walked me through the documents, I read every page, not as a formality, but as a habit I had built over more than a decade of professional fieldwork. The access road came up on page 11. It ran along the eastern boundary of my property for approximately 0.6 of a mile, connecting at the north end to County Route 7, and it had been established as an easement in the original 1987 survey when the larger parcel was subdivided. The easement language was general. Access road for agricultural and commercial use, recorded with the county under reference number 87-041. My attorney flagged it as routine. Easements of this kind existed on a significant portion of the rural parcels in the county, she explained, particularly on land that had historically changed hands as part of larger agricultural tracts. The easement meant I had the legal right to use that road regardless of who owned the adjacent land it ran beside. An easement is a recorded legal right to use another party's land for a specific purpose, not to own it, but to use it in a defined way. The crucial feature of most easements is that they run with the land, meaning they are attached to the property itself rather than to any individual owner. When a property is sold, all recorded easements transfer with it. The buyer acquires the land subject to those rights, whether they read about them or not. When Hargrove Hospitality Group LLC purchased the Caldwell parcel in 2019, they purchased it with easement 87-041 and easement 74-118, both fully active and recorded against the title. Whether their attorneys discovered them in the title search was an internal matter. The easements existed. I noted the easement, had my attorney confirm it was properly recorded and current, made a copy, placed it in the fireproof box, and didn't think about it again for more than a decade. There was no reason to. The road had always been there. I used it for timber deliveries, equipment access, loads of fence posts and gravel, and the occasional piece of used equipment I picked up at farm auctions in the surrounding counties. It was a working road on a working piece of property, and the family who owned the land it ran adjacent to, the Caldwells, had never once raised an objection in all my years of using it. The Caldwells were 3 generations on that ridge. Walter Caldwell, the patriarch, had purchased the upper parcel in 1961 and spent 40 years running a mixed cattle and hay operation before his health began failing in the late 1990s. His son Raymond took over the day-to-day operations around that time and shifted the operation toward leasing the open pasture to neighboring farms, rather than stocking cattle himself. It was easier to manage, and the lease income was steady. Walter's granddaughter, Claire, had grown up on the property and was in her 30s by the time I bought my 42 acres. She handled the property records and the lease paperwork while working as a paralegal for a firm in town. It was Claire who walked my fence line with me in the first summer I owned the place, in the hot, insect-loud weeks of July, when the hardwood canopy was full and the property line markers were partly hidden by undergrowth. She knew the boundary exactly, which corners matched the recorded survey and which had drifted over the decades, which stretches of fencing were on the line and which ran a few feet inside it. She had grown up watching her father walk it and had taken over the task herself when Raymond's knees went bad. She also knew about the second easement. "There's an old logging road on our north boundary," she said, pointing up the slope to where the ridge leveled off before rising again. "It's overgrown now, hasn't been used in 20 years probably, maybe more. But it's in the county records. Goes back to when my grandfather bought the land. Some timber outfit used it before he purchased, and the easement got recorded as part of the original title transfer." She looked at it for a moment, then looked at me. "You might want to know that, in case it ever comes up." I walked it that afternoon. The 1974 easement, reference number 74-118 in the Blue Ridge County records, described a freight and agricultural equipment passage running along the northern section of the Caldwell upper parcel, parallel to, but approximately 80 feet north of the established access road. The legal language was explicit and unqualified. Freight and agricultural equipment passage, unrestricted by vehicle type or load in perpetuity. The right had been granted to the original timber operation, and had passed through the chain of title to each subsequent property owner, which now included me. The road itself was barely visible. 2 faint vehicle ruts through the accumulated leaf litter of decades, a section of old rail fence post still standing at the upper terminus, and at the lower end the original gate, a ranch-style pipe construction, horizontal rails welded to a center post, hinged on a frame set in concrete that had weathered to a gray-green. Rusted to a deep orange on its surface, but still functional on its hinges. The gate sat at the edge of an opening in the tree line. Claire pressed a key into my palm during our fence walk that afternoon, along with a hand-copied Xerox of the 1974 survey plat she'd found in her grandfather's papers. "In case you ever need it," she said. I thanked her, put both items in the fireproof box when I got home, and largely forgot about them. There was no reason to remember them. I had a road. I used it. Walter Caldwell died in the spring of 2019 at 91 years old. Raymond had predeceased him. Claire managed the estate sale through a Raleigh firm that handled rural land transactions, and the buyer appeared in the public record only as Hargrove Hospitality Group, LLC, until a rezoning application showed up in the county planning notices that October. I read it on a Tuesday evening at the county's website. A 140-room mountain lodge, an event pavilion, 2 restaurants, a spa, what the application called curated outdoor experiences. 14 months of projected construction. The survey map attached to the application placed their eastern development footprint approximately 60 feet from my property line. I read the application twice. Then I went to the fireproof box, pulled out both easement documents, and sat at the kitchen table looking at them for a long time. Construction began the following January and was running full scale by March. 18 months of heavy equipment on the ridge, blasting for the lodge foundation, grading for the access roads and parking structures, drainage work that rerouted a natural seep along the hillside in a way that increased runoff across my north pasture by a measurable amount. I photographed the pasture conditions at 2-week intervals through the wet season. I noted the dates and the moisture readings in my field notebook. I did not file a complaint. The drainage change was real, but manageable with some regrading of my own, and I had learned in 19 years that the problems worth formal action were the ones that couldn't be absorbed. The Hargrove Mountain Resort opened in June of 2021. 140 rooms, the pavilion, the spa, 2 restaurants with menus I found online one evening out of curiosity. Their landscaping was institutional grade, the kind that reads as deliberate without reading as natural. Boulders placed by machine to suggest that boulders had simply fallen there. From my property, the resort was mostly invisible. Its roofline showed above the tree line on the ridge, and at night I could see the warm amber of their pathway lighting through the pines, steady as lamplight. Derek Voss introduced himself at my fence line in August of 2021. He was mid-40s, trim, dressed in the business casual outdoor wear that resort management favors, a collar under a fleece vest, good hiking boots that hadn't seen a trail. He spoke in the careful cadence of someone trained in hospitality. Everything was guest experience, brand alignment, visual corridor management. He was pleasant. He mentioned that the resort was considering some landscaping enhancements along the eastern boundary. He used the phrase, enhancing the arrival corridor, and wanted to flag it as a neighborly courtesy. I said I appreciated him letting me know. He said the resort would certainly be respectful of property lines. I nodded. He left. That evening, I pulled both easement documents from the box again. I read them against the county's online parcel records, confirmed neither had been vacated or modified since recording, and put them back. Then I sat for a while at the kitchen table and thought about what enhancing the arrival corridor might mean in practice. 6 months passed with no change. The access road stayed open. I drove it twice weekly at minimum, more during active timber work. Voss waved from across the fence line when he happened to be out. The resort's guests were oriented toward the western slope and the valley views, and the resort's operational footprint didn't extend to the eastern boundary in any visible way. It almost felt like adjacency without friction. It almost felt like it was going to be fine. I was driving the access road at dusk one evening in late February, the kind of late winter dusk that lasts about 20 minutes before it collapses into dark. The resort's new pathway lights were coming on through the trees one by one as their timer triggered them. Amber in the last light, steady and warm. The gravel ran straight ahead of my truck. The tree line was bare. I thought, it's still just a road. The landscaping crew arrived in late April of 2022. I heard them before I saw them. The low mechanical growl of a compact excavator working its way along the resort's eastern boundary. And when I drove the access road that morning, I found a 3-man crew installing ornamental granite boulders along the resort side of the corridor. The boulders were substantial, 200 to 250 pounds each, set at deliberate intervals and angled to suggest natural outcropping. Between them, the crew was laying in a planted berm of low-growing juniper over compressed fill soil, running the full length of the resort's boundary face. It did not technically block the road. The corridor remained passable. But I pulled over, stepped out, and measured the clearance with the tape measure I keep clipped to the inside of my truck door. A standard timber truck body runs 102 inches wide. The narrowed section now offered approximately 108 inches of clearance at its tightest point, 6 inches of margin. On a straight road in dry conditions, adequate. With a full load on, in standing water or early frost, when a loaded trailer shifts its center of gravity by 6 inches on a wet surface, not comfortable. I called Derek Voss from the roadside. He answered after 2 rings. The boulders are entirely on our side of the boundary, he said, before I had finished describing what I was looking at. Purely aesthetic. The road access is not affected. The clearance has been reduced at 6 measured points. I'd need to have our facilities team look at the specific measurements, but as an aesthetic installation within our boundary, I don't believe there's an issue here. I took 43 photographs before I left. I recorded the clearance measurement at each of the 6 points in my field notebook with the date, time, and the location reference relative to the corner markers. I did not contact an attorney. Not yet. The boulders were on their side. The road was still passable. What I had was a documented change in conditions, not yet an obstruction. I filed the notebook with the photographs and went back to work. By August of 2022, I had a timber harvest contracted. A crew I had used 4 times on this property. 3 trucks, 2-day operation, standing timber sale to a mill 40 minutes north on Route 19. I had used this exact arrangement, this same road, 6 times in 19 years, without a complication of any kind. I scheduled the harvest for a Tuesday, confirmed with the mill on the Friday before, and drove out to the access road entrance that Monday evening to check conditions. The road was clear, the boulders were still there. The access was still 6 inches tighter than it had been the previous autumn, but the summer had been dry and the ground was firm. I went home satisfied that the harvest would run without difficulty. I arrived at the access road entrance at 6 a.m. Tuesday to find a resort maintenance vehicle, a white 1-ton truck with the Hargrove logo on the door, parked across the road's mouth at a 45-degree angle. The engine was off, no driver visible. Behind it, a 2-man crew was installing what I later learned Voss would characterize as a guest safety barrier, a low decorative fence of horizontal cedar rails set in fresh concrete footings, the footings still curing, the rails running in a line that crossed the access road entrance diagonally. I sat in the cab of my truck for a moment. The crew worked without looking at me. I called Voss. He answered on the 3rd ring. "That installation is on our side of the property line," he said, before I had finished describing it. "Our team confirmed the boundary markers this morning prior to beginning work. It is physically positioned across the entrance to my easement. I understand your concern, and I take it seriously. I'll have our legal team look into the easement question. I want to be honest with you. These things can be more ambiguous than they initially appear. There is nothing ambiguous about a recorded easement. I appreciate your perspective. Someone will follow up with you in writing." The timber crew arrived at 6:45. The foreman, a man named Garrett who had run harvests on my property twice before, looked at the decorative fence, looked at the maintenance truck, looked at me. I told him the situation. We waited. At 7:30, I called the county planning office and reported an obstruction of a recorded easement. The officer I reached said it sounded like a civil matter and suggested I contact an attorney. At 10:15, with no resolution and the contracted day rate accumulating, I sent Garrett and the crew home. The cost of that day, crew wages, the mill's scheduling penalty, equipment standby charges, came to $1,940. I itemized it in my ledger that evening, with receipts clipped to the page. That afternoon, I called Sandra Okafor. Sandra had practiced land use and property law in western North Carolina for 22 years. Her office was in Asheville, in a building on the south side of downtown that used to be a machine shop. She was methodical in the way that the best property attorneys are methodical. She didn't reach for dramatic language. She reached for the document. When I laid out the situation over the phone that afternoon, she asked 3 questions in sequence, without preamble. What is the easement reference number? When was it recorded? Has the corridor been used continuously for its stated purpose without interruption? I gave her the answers. 87-041-1987, and yes, without interruption for 19 years, and she said she would send a letter. The letter went out in October 2022. It cited the easement by reference number and recording date, reproduced the relevant language from the county record, and stated the position plainly. The access road was subject to a recorded easement for agricultural and commercial use. The recent installation of structures within or across the easement corridor constituted interference with the easement holder's legal rights, and the resort was required to remove the obstructions and restore the corridor to its original condition within 30 days. The resort's corporate counsel responded 6 weeks later, a 4-page letter from a Charlotte firm with offices in 4 states. Their position was carefully worded, but its substance was this: The easement existed, but its scope was subject to interpretation. Specifically, they argued that the phrase agricultural and commercial use in the easement language contemplated pedestrian access and light vehicle passage, not commercial timber operations involving vehicles weighing upward of 80,000 pounds fully loaded. They cited no case law directly on point. They cited general interpretive principles. They suggested that mediation might be productive. When an easement's language doesn't specify vehicle type or weight capacity, courts determine scope by looking at two things: the original intent at the time the easement was created and the established historical pattern of use. If commercial timber trucks used that road regularly for decades before any dispute arose, that pattern of use becomes part of the easement's legally recognized scope. The burden then falls on the party claiming a narrower interpretation to demonstrate that the road was never used for heavy commercial purposes, an extremely difficult standard to meet after 35 years of documented operation. The resort's attorneys weren't wrong to try the argument. It was a legitimate legal position, but it was also a delay strategy, and in the timber business, where harvest windows are seasonal and mill contracts are time-sensitive, delay costs real money. Sandra's assessment was direct. Their argument was thin, she said. Courts in North Carolina had consistently looked to historical use to define scope, and the documented history of timber truck access on this road was extensive. But thin arguments from large institutional law firms in good standing slow things down for months, regardless of their merits, and the resort understood the commercial value of that delay. She recommended we continue documenting every obstruction while preparing for the possibility of formal litigation. I went back to work. I documented. I waited. January 16th, 2023, a Monday. I woke at 5:45 a.m. to a sound I had been half expecting for some time: concrete trucks working in the dark on the ridge. By the time I drove to the access road entrance at 7 a.m., the installation was done. 2 stone pillars, each approximately 4 feet in diameter and 6 feet tall, had been set in concrete footings that had been poured overnight, the footings still warm when I pressed my hand against the base of one of them, the concrete not yet fully cured. Between the pillars, a wrought iron arch spelled out the resort's name in cast lettering: Hargrove Mountain Resort, backlit by recessed LED fixtures already operational at 7 a.m., glowing a warm white in the gray January morning. The clearance between the inner faces of the pillar bases was 58 inches, the width of a standard passenger car, nothing wider. The access road was closed, not legally closed, not closed by any court order or official ruling, closed by 2 decorative columns of stone and a name written in iron on a Tuesday morning in January, without a single legal instrument authorizing it. A typed note on resort letterhead arrived in my mailbox that same afternoon. Voss's signature at the bottom. We hope the new entrance feature enhances the character of the corridor for all users and contributes positively to the aesthetic experience of the surrounding area. Should you require access through the resort property for any purpose, please contact our guest services team to arrange a mutually agreeable solution. I read it standing at the mailbox. Then I read it again. Should you require access? A mutually agreeable solution. The road had been there for 35 years. I had been using it continuously for 19, and Hargrove Mountain Resort was inviting me to contact their guest services team to arrange a solution. I put the letter in the box. Here's what I want to say about that moment, and I won't return to it. I am not a man who carries anger well or long. Frustration, yes. The specific frustration of watching something legally plain and thoroughly documented be treated as though it were a matter of opinion. That I felt. But anger makes noise, and noise produces mistakes, and the one thing I had going for me in this situation was that I had made no mistakes. I intended to keep it that way, because I had known for 14 months about a second road, a road that predated the first one, a road the resort had no idea existed. In April of 2022, while Voss's landscaping crew was setting ornamental granite along my access road, I hired a licensed surveyor named Paul Ingram to walk the 1974 freight easement with me and mark its legal boundaries. Paul had been working survey work in Blue Ridge County for 15 years and knew the older plat records the way a reader knows a familiar book, not just the content, but the filing quirks, the notation conventions, the surveyors whose measurements ran a little long, and the ones who ran a little short. We spent a full day on the ridge together, he with his transit and rod and GPS unit, me with the county copy of the 1974 survey. By afternoon, he had placed 12 boundary stakes along the corridor, each flagged in orange and noted on his field record. What Paul found, and what I had suspected since walking the corridor myself years earlier, was this. The resort's own construction activity had inadvertently improved the freight route's accessibility. In building their event pavilion access path along the northern edge of their development footprint, the resort's grading crews had cleared brush and leveled terrain on the resort side of the freight easement corridor, not within the easement itself, but adjacent to it, along the margin that had been overgrown for decades. The effect was that the old logging road, which had been barely walkable when I first went up there in 2003, now had a cleared and level shoulder on one side of it for most of its length. The 1974 freight route was more passable in 2022 than it had been in 40 years, and the resort had done the clearing without knowing the road existed. In June of 2022, I called the Blue Ridge County Recorder's office and asked for written confirmation that easement number 74-118 remained active in the county records. Not vacated, not subject to any modification, not involved in any pending legal proceeding. The clerk confirmed all of that in writing within 2 weeks. I filed the letter. In August of 2022, the same week the resort parked its maintenance vehicle across my primary road and forced my timber crew to stand down, I drove the freight route in my truck from the county road connection at the top of the ridge down to the lower gate. The route was passable, tight in 2 places where the old corridor narrowed around a rock outcropping and again near the lower bend, but I got out at both points with my measuring tape. The clearance was adequate for a fully loaded timber truck at both locations, with margin. I brought all of this to Sandra in September 2022, before she had sent the first demand letter about the primary road. She was quiet for a long moment when I finished. Then she pulled up the county records on her computer and read the 1974 easement language aloud from the screen. Freight and agricultural equipment passage, unrestricted by vehicle type or load, in perpetuity. She said, "They can't run a scope argument against this language. Unrestricted by vehicle type or load is as explicit as easement language gets. There's no light vehicle reading available here. The word freight means freight." I asked the question I had been sitting with since August. If I use it, if I open the freight route and run my timber operation through it, can they legally stop me? She read the document once more before answering. Not without a temporary restraining order, and to get one they'd need to show a court they're likely to prevail on the merits. Their only available argument is abandonment, that the easement has been dormant long enough to be considered vacated. And what happens to that argument given the last 14 months? She paused. When she answered, she spoke slowly, the way she did when she was choosing words that would need to hold up. Easement abandonment under North Carolina case law requires 2 elements: non-use, and demonstrated intent to abandon. Non-use alone, even for decades, is legally insufficient. Intent must be separately proved. And here is the problem they've created for themselves. Another pause. Every time they've blocked your primary road, the parked vehicle, the cedar fence, the stone gateway, they have produced a documented record establishing why the freight route hasn't been in active use. They've documented their own obstruction of your access, not your intent to give it up. Those are 2 fundamentally different things. I let that settle. Their own obstruction of the primary road has been building the legal argument against abandonment of the secondary one. Correct. Every letter they've sent, every structure they've installed, every day they've delayed your operations, all of it is evidence that you were prevented from using your easements, not that you chose to abandon them. They have spent 14 months creating a paper trail that defeats the only legal theory available to them. I went home and called my timber contractor, told him to put us back on the schedule, told him we'd be using a different road. He asked if there was likely to be trouble with the resort. I told him I didn't expect any that couldn't be managed with documents. On March 4th, 2023, a certified letter from Hargrove Mountain Resort arrived at my mailbox. Inside was a formal notification that the resort had installed a keypad-controlled vehicle access gate across the primary easement road, citing guest safety protocol and the need to manage traffic on the resort campus. The letter informed me that as a courtesy to adjacent property owners, the resort would provide me with a gate access code upon request, obtainable by contacting the guest services team during business hours, Monday through Friday, 9 a.m. to 5 p.m. I stood at the mailbox and read it twice, as a courtesy. The phrasing was precise and intentional. A courtesy was something extended at the giver's discretion, something that could be withdrawn, as though the road were theirs to administer access to, as though what I had recorded in the county records 19 years ago was a request rather than a right. I photographed the letter on the spot. I forwarded the photograph to Sandra with a single line. "We're ready." She confirmed the following morning. We had easement 87-041, recorded 1987, current. We had easement 74-118, recorded 1974, confirmed active by the county recorder in June 2022. We had Paul Ingram's survey report with all 12 boundary stakes documented. We had Sandra's written legal opinion, dated October 2022, that use of the freight route was lawful, active, and not subject to scope dispute. We had a 14-month chain of documented obstruction of the primary road, the boulders, the maintenance vehicle, the cedar fence, the stone gateway, the keypad gate. Each instance photographed, dated, and filed. We had, in Sandra's words when she went through the list, everything we needed and nothing we didn't. The timber contractor scheduled the crew for the Thursday of that week, 2 days out, 3 trucks. Garrett and the same crew that had stood idle at the entrance for 4.5 hours the previous August, watching the resort's cedar fence installation continue while the contracted day rate burned. Garrett asked me the same question he always asked at the start of a job. "What road are we on?" "The North Freight route," I told him. "I'll have it open before you arrive." He said he'd need a few minutes with the approach grade to figure the load plan. I told him the route was wider than the primary road at its upper section, narrower at 2 points below, and that I'd have the measurements for him in the morning. I drove up to the ridge Wednesday evening, the night before, while there was still enough light to walk the corridor one more time. The resort's event pavilion was lit across the hill, warm and steady through the pines, the kind of light that spills out of a building where something is being celebrated. I could hear, indistinctly, the sound of voices and music. A large gathering of some kind. The bass notes of a band, the layered sound of a crowd. I couldn't make out any specifics, just the general murmur of a large number of people in a warm place on a cold evening, which has its own texture even at distance. I walked the freight route from the lower gate to the county road connection at the top, checking the 2 narrow sections with my measuring tape in the beam of my headlamp. The clearances were unchanged from August. The resort's pavilion access path ran along my left for most of the descent, its graded surface pale in the headlamp beam, and the clearing it had opened along that side of the corridor continued to provide the additional margin that made the route viable for loaded trucks. The ground underfoot was frozen, not the deep locked freeze of January, but the shallow crust that forms on nights that drop into the upper 20s and thaw by 10 in the morning. It crunched softly under my boots. The air had the sharp, resinous smell of cold pine, the kind of smell that cuts through everything else at altitude in late winter. I stood at the upper end of the corridor for a minute, looking down the ridge. I thought about the survey crew that had walked this same ground in 1974. 4 or 5 men, most likely, with transit levels and steel chains, and the particular patience of men doing precise work in an imprecise landscape. They had measured the corridor, noted the boundaries, filed the paperwork at the county courthouse, and gone home. That document had sat in the county records for 49 years. It had survived the Caldwell's entire tenure on the land, the estate sale, the resort purchase, the construction, the landscaping campaigns, and the decorative gateways and the certified letters. 49 years, filed and current and waiting. I went home, set my alarm for 2:30 a.m. I was at the lower gate at 3:04 a.m., 27 degrees. The gate was the original pipe construction, horizontal rails welded to a center post, hinged on a steel pipe frame set in concrete that the Caldwells had poured sometime in the early 1980s, I estimated, based on the construction style and the degree of surface oxidation. The chain securing the gate was original as well, a 3/8-inch proof coil that had been there long enough to develop a patina of rust on its outer links while remaining structurally sound at its core. The padlock was a standard hardware store model, the same brand my father had used on his barn doors, and Claire Caldwell had given me the key to it 11 years earlier, pressed into my palm during the fence line walk, along with the copy of the 1974 plat. I want to be precise about this, because it matters legally, and it matters to me personally. I did not cut the lock. I did not force the gate. I did not break or damage or circumvent any structure on the resort's property. I inserted a key that had been in my legal possession for 11 years into a padlock on a gate that stood at the entrance to an easement corridor I had the fully documented right to use, and I opened it. The gate swung inward on its hinges more smoothly than I expected given the temperature and the rust. It moved with the particular ease of something old and well-made that has simply been left alone. I drove through. I left the gate standing open behind me, not as a statement, but as a practical matter. The trucks would need to clear it at 5 a.m. without stopping to work a latch in the dark. I called Garrett from the upper terminus of the freight route, where the old logging road met the county route. "We're open," I said. "Bring the trucks. Bring the—" He said he'd have the first one there inside 40 minutes. By 5 a.m., 2 trucks were running the freight route, and Garrett's third was staged at the county road connection, waiting for a clear pass. The harvest was on the upper 40, the black walnut and the mature tulip poplar I had been planting for 3 years. Trees that were ready, and a mill contract that had been rescheduled twice because of the access road situation. The freight route gave direct access to the upper loading zone without the grade complication of the primary road's lower approach. Garrett noted, making his first descent with a full load, that the angle was actually cleaner than the approach we'd used on previous harvests. I didn't remark on it. The trucks moved. Trucks. I had prepared 3 document sets. One rode in the cab of my truck. One I had sent by email to the county sheriff's non-emergency line at 4 a.m. with a cover note, "Operating under recorded easement number 74-118, Blue Ridge County. Accessing freight and agricultural passage as documented, notifying as a professional courtesy. Contact Sandra Okafor at number with any questions." The third set I had sealed in a manila envelope and left on the hood of my truck where it was visible from the road, because I had learned, in 19 years of land ownership and 12 years before that in survey work, that a visible document on a truck hood is the fastest way to communicate that you have done your preparation. Each set contained the 1974 easement, the county recorder's written confirmation of its active status, Paul Ingram's survey report with the boundary stake locations, Sandra's legal opinion, and a 1-page plain language summary I had written myself describing the legal basis for the operation, the history of obstruction of the primary road, and the specific legal standard for easement abandonment under North Carolina case law. I had learned that the best legal documents are the ones that don't require an attorney to interpret on the spot at 6 a.m. in a field. At 6:15 a.m., a resort-branded expedition came down the resort's access drive and pulled up outside the lower gate. Derek Voss got out. He was accompanied by 2 men I hadn't seen before, resort security staff, both in matching fleece and lanyards, both looking like they had been reached by phone 30 minutes ago. Garrett's third truck was on its first full pass of the route. The sound of the diesel engine working down the grade was clear and steady in the morning air. Voss walked toward me. He covered the distance between us with the deliberate pace of someone who is managing their composure carefully. His face had the expression of a man who has just found a structural problem in something he thought was solid. Not yet anger, not yet panic, something in between, assessing. "What is this?" he said. I handed him the document set. He took it. He looked at the top page. The second. When he reached the recording date on the 1974 easement, 74-118, filed October 3rd, 1974, in the county recorder's stamp, his eyes stayed there for several seconds. "This road hasn't been used in decades," he said. "It's legally abandoned." I handed him the second document, the county recorder's written confirmation, dated June 9th, 2022, that easement 74-118 remained active, unvacated, and not subject to any pending legal proceeding. Abandonment requires demonstrated intent, I said. Non-use alone is not the standard. And the documented chain of obstruction of my primary access road, which is contained in your own correspondence over the last 14 months, establishes why the freight route has not been in active use. Your letters and installations have been creating the evidence against your own abandonment argument. He looked at the confirmation letter. He looked at the trucks. He pulled his phone from his vest pocket and walked a few steps away, turning his back slightly. I didn't try to hear what he said. The trucks ran. Garrett's second truck came down through the corridor and made the turn toward the county road, its load shifting slightly on the grade, the trailer brakes catching, the particular sound of a properly loaded timber truck making a controlled descent, which I've always found to be one of the more satisfying sounds in the world. 22 minutes later, a county sheriff's cruiser pulled in from the county road, not in response to anything I had filed. The non-emergency notification had been a courtesy, not a request for assistance. Voss had called. The deputy who got out was named Harlan Webb. I had met him once at the county planning office during an unrelated matter, and he carried himself with the particular efficiency of someone who has spent a career arriving at property disputes and needs very little time to understand what he is looking at. He walked toward me first. I handed him the document set before he asked for anything. He read through it with the same unhurried care that the deputy in the opening of this story brought to the same set of documents. He turned pages. He found the recording stamp on the 1974 easement and looked at it the way Deputy Webb would have needed to look at it, confirming the date, confirming the county, confirming the reference number. He found Sandra's legal opinion and read the operative paragraph. Then he looked up at the trucks making their runs above us on the ridge. Easement 74-118, he said. County recorded. Filed 1974. Active as of written confirmation from the county recorder, June 2022. You notified the non-emergency line. At 4 a.m., I have the confirmation number if you need it. He was quiet for a moment. Then he walked over to Derek Voss. I stayed at the gate. What passed between them I know only from what I could observe across 20 feet of open ground. Voss talked at length, showed the deputy something on his phone screen, gestured toward the freight corridor, gestured toward my truck. The deputy listened with his hands at his sides. When Voss finished, the deputy said something brief. He pointed at the corridor. He pointed at the county road at the top of the ridge. Then he turned and walked back toward his cruiser. Sir, Deputy Webb said to Voss as he passed him, not slowing down, the easement is recorded and active. If you wish to challenge the operation, the appropriate venue is civil court. This is not a matter for law enforcement. Voss stood at the gate. The security staff stood behind him. Garrett's third truck came down through the corridor and turned onto the county road, loaded, moving. Voss made 2 more phone calls that morning. The first lasted 11 minutes. The second lasted 4. Neither of them produced any additional personnel or any further legal intervention. At 9:30, without speaking to me again, he got back into the expedition and drove back toward the resort. The security staff followed in a separate vehicle. The harvest ran for 2 full days. We removed the standing timber, loaded the trucks, cleared the upper zone, and closed out the site. On the second afternoon, as Garrett's crew finished the cleanup work, I walked the freight corridor one final time from bottom to top. The ground where the trucks had passed was compressed and rutted in 2 places, but intact. I latched the gate at the lower end and locked it with Claire Caldwell's padlock, the key going back into my jacket pocket, and walked back to my truck through the quiet of a March afternoon in the Blue Ridge, the kind of quiet that follows work that is finished. I drove home, put the kettle on the burner, let it come to a full boil, and then let it sit there until it went cold on the stove, which is what happens when you have been concentrating on something else. Hargrove Mountain Resorts Corporate Counsel filed for a temporary restraining order in Blue Ridge County Superior Court on March 8th, 3 days after the timber operation concluded. The filing advanced 2 arguments: that easement 74-118 had been abandoned through extended non-use, and that even if it remained technically valid, its scope did not permit commercial timber truck traffic. The court denied the TRO application on March 21st. The denial ran 14 pages, which is long for a TRO ruling and short for what it contained. The judge addressed the abandonment argument directly. The documented record of obstruction of the property owner's primary access easement, established entirely through the opposing party's own correspondence and construction records, fundamentally undermined any claim that non-use of the freight easement reflected the holder's intent to abandon. Intent, the ruling noted, must be affirmatively demonstrated and cannot be inferred from inaction attributable to another party's interference. On scope, the easement language was explicit and unambiguous. Freight and agricultural equipment passage, unrestricted by vehicle type or load in perpetuity. There was nothing to interpret. The resort's council filed a notice of intent to appeal in April. Sandra called me the morning she received it. "They're not going to appeal," she said. "An appeal brief on these facts would be expensive to write and nearly impossible to win. This is a settlement position. They want something to negotiate with before they come to the table." She was right. A settlement conference was scheduled for June. By late July, both parties had executed a settlement agreement. In North Carolina, as in most states, a recorded easement can be extinguished without a court order only through formal release, a written relinquishment signed by the easement holder, or through abandonment, which is a legal conclusion requiring proof of both extended non-use and a clear, affirmative intent by the holder to give up the right permanently. Actions demonstrating intent include formally releasing the easement in writing, removing infrastructure associated with it, or taking other steps inconsistent with continued use. What does not establish intent is non-use caused by another party's obstruction. The resort had spent 14 months creating a correspondence record and a construction history that documented obstruction, not abandonment. Every block delivery, every installed barrier, every certified letter offering a courtesy access code had been, from a legal standpoint, an argument against the only theory they had available. The settlement terms were recorded in a new instrument filed with the county in August 2023. Hargrove Mountain Resort acknowledged both the 1987 access road easement and the 1974 freight easement as active, valid, and binding encumbrances on the property. The decorative stone gateway, the pillars, the iron arch, the resort name in cast lettering, the recessed LED fixtures, the concrete footings, was to be removed at the resort's expense within 60 days. Both easement corridors were to be maintained in a passable condition for the purposes described in each easement's language. Attorney's fees for the demand letter phase and the TRO defense were paid by Hargrove Hospitality Group, LLC. No admission of wrongdoing appeared in the language, which is standard in settlements of this kind, and which matters less than the recorded instrument and the absence of stone pillars. The removal crew arrived on a Wednesday in early October. I watched from my truck on the county road, 100 yards from the entrance, not because I needed to witness it, but because I had driven past those pillars every time I'd left the property for 9 months, and I wanted to see what the road looked like without them. The crew used a compact hydraulic excavator to break the footings. It took longer than I expected. The footings were deeper than a decorative installation warranted, which told me someone had built them to be difficult to remove. The iron arch came down in sections, cut with a torch. By early afternoon, the material was loaded on a flatbed, and the entrance was open. Gravel road, tree line, county route beyond. 2 rectangular concrete pads remained in the gravel where the pillar bases had been. Breaking them out would have required a larger machine and a separate disposal contract, and Voss, or whoever was authorizing expenditures at that point, had apparently determined it wasn't worth the cost. I understood the calculation. You spend enough on something before you recognize it as a mistake, and at a certain point, the accounting shifts towards stopping losses rather than restoring original conditions. Derek Voss had been reassigned to a resort property on the South Carolina coast sometime that summer. I learned this from the county planning office during an unrelated conversation about a drainage permit application I had filed. The officer mentioned it in the way that county offices mention personnel changes at neighboring institutions. Factual, incidental, the kind of information that surfaces in passing. I said I hoped the new assignment suited him. Then we returned to the drainage permit. In November, I scheduled a timber harvest using the primary access road, the first since the gateway came down. Garrett and his crew arrived at 6 a.m. I was there before them. The road was exactly what it had always been. Single-lane gravel, straight run to the county route, a little rough in the lower section where the grade change accelerates drainage. The two concrete pads sat in the gravel at the entrance, flush with the surface now that the pillars were gone. They didn't obstruct anything. Garrett drove over them on the first pass without mentioning them. The operation ran 2 days without incident. When it was done, I opened the fireproof box and added the settlement document, the recorded instrument, county-stamped August 2023, to the back of the file. I counted the documents in the box while I had it open, the way I count things out of habit. 37. The deed, the 2 surveys, the 2 easement filings, the county recorder's confirmation, Paul Ingram's survey report, Sandra's legal opinion, every letter the resort had sent, every response Sandra had sent back. The itemized ledger entry for the lost August 2022 harvest day, $1,940, with receipts. The TRO denial, the settlement, 37 documents. I closed the latch. I put the box back on its shelf. Between the property tax records going back to 2003 and the timber sale contracts going back to 2006, at the back of the closet in the spare room where it has always lived. And I closed the closet door. Some evenings now, when the light is right and the air is still, I stand at the eastern edge of my property and look toward the ridge. The resort's event pavilion runs most weekends. I can see the glow of it through the pines on Friday and Saturday nights, amber and steady, the way it has always looked. I can hear it sometimes when the conditions are right. Music, voices, the particular sound of a crowd of people in a well-heated room on a cold night, which has a warmth to it, even at distance. I go inside. The road is open. The box is full. The kettle takes about 4 minutes.